Lower courts, lower courts, lower, lower, lower courts, lower courts. Yeah, yeah, lower courts. Episode 27. Okay, so our federal court system is broken up into the Supreme Court and lower courts. Today we're going to talk about lower courts. Episode 28 is going to talk about the Supreme Court. So let's start with the role of the courts. The courts have three main roles: resolving disputes, setting precedents, and interpreting the law. So, resolving disputes. The lower courts hear cases and controversies, reviewing and resolving specific disputes between specific parties. That means that you actually have to have suffered something, like a specific injury or something along those lines, in order to bring a lawsuit forward. Next up, setting precedents. Although the courts rule only on specific cases, their decisions have much broader and more far-reaching consequences. This is because, in addition to announcing their specific decisions, the courts also provide legal grounds or reasoning for these decisions. These legal grounds, or like the baseline, is also known as a precedent. So if a similar case is heard in the future, they will look back at that case and see how they were ruled, and based on that, that's how the judges will make their rulings. Then we get to interpreting the law. Now, this is where, interpretation comes in. See what I did there? Interpreting the law. Interpretation. Okay. Some people believe that the law should be based on a strict constitution. That means that you should interpret the law strictly as it was written, and that's how it is, right? It was written one way for a reason, and that's how it should always stay. Other people, on the other hand, prefer a living constitution. And that basically means that the Constitution and other laws must be interpreted in light of current political and social conditions. So, some people, strict constitutionists, believe that it should be followed exactly how it was written back when? What was that date when it was written? I'm sorry, I didn't hear you. Did you say 1787? Because if you did, you were right. Anyways, what was I saying? Oh, yeah, right. Some people believe that it should be followed exactly as it was written way back when in 1787. Other people believe that it should be followed as society and laws have changed to date. Not just laws, but society has changed. Technology has changed. Life has changed. So the Constitution should also be interpreted with people's lives changing. So, for example, think back to the 8th Amendment. 8th Amendment says no cruel or unusual punishment. Now, cruel and unusual punishment back in 1787 was completely different than cruel and unusual punishment today. Back then, you could publicly beat someone, and it was pretty normal. Now, today, if you publicly beat someone, that would be considered cruel and unusual punishment. So that's where the strict interpretation and a loose interpretation could find conflict. Another example many of you brought up when you were doing your persuasive essays on gun control was that in 1787, the Second Amendment was written in there to protect us from, the British. And many of you argued that that's no longer a need. So that maybe we do need a change of that, or to interpret the Second Amendment differently. Article 3 of the Constitution states that the judicial power of the United States shall be vested in one Supreme Court and in such inferior courts as Congress may establish. Now, back in 1789, Congress decided to do so. They set up lower federal courts. And what they decided was that the federal lower courts were given their jurisdiction or their authority to interpret and administer the law from the Constitution. Lower federal courts have something called original jurisdiction, which means that they have the authority to hear a case's initial trial only over cases arising under the Constitution. But there's a few other things they can rule on as well. They can rule on other federal laws over those other federal laws involving diplomats, treaties, state governments, and the U.S. government and the citizens of other countries or more than one state. So what I did here is I took a picture of the book because I love doing that. This chart gives you a good idea of what types of cases the lower federal courts can hear. So they can hear cases in which a person is accused of disobeying the U.S. Constitution, violating a U.S. treaty, breaking federal law passed by Congress. The U.S. government or a U.S. citizen is charged with an offense by a foreign nation. A person is accused of committing a crime on a U.S. ship at sea. A U.S. ambassador or other foreign service officials is accused of breaking the law of the country in which he or she is stationed in. A person is accused of committing a crime on certain types of federal property, and a citizen of one state brings a lawsuit against a citizen of another state. Now, I would go into these in detail, but I actually think these are pretty self-explanatory. However, if you have questions about any of them, come with your questions to class. Okay, let's talk about how these courts are organized. So, lower courts are divided into district courts and courts of appeals. These two types of courts play different roles in the legal system. The lower court system also includes several specialized courts. Okay, so district courts. Trial courts of the federal system are called district courts. These courts are assigned to specific geographic areas and have original jurisdiction over federal cases that arise there. In Orange County, we are in the Central District of California. And in fact, in Santa Ana, we have the district courts for all of Orange County. Not too far from school, actually. District courts engage in the oldest and most fundamental judicial activity, making decision in a dispute. Any trial decision is based on the facts and the law. The basic task of the district courts is to determine the facts and then reach a verdict by applying them to the law. And all that reaching a verdict means is coming to a conclusion. In district courts, cases are tried before a district court judge and a jury. But defendants can waive or give up the right to their jury. In criminal cases, these are also held at the district courts. In criminal cases, the U.S. attorney from the Justice Department serves as the prosecutor. So generally we hear it as the DA, the district attorney. They serve as the prosecutor. But in civil cases, the opposing parties are represented by their own attorneys. And so one would be the defense and one would be the plaintiff. Moving along to court appeals. So, appeals of cases from the U.S. district courts are heard by the courts of appeals. Now, what does appeals even mean? In case you don't know, it means to apply to a higher court for a reversal of the decision of the lower court. About 1/3 of court decisions are appealed. However, only around 1/5 of them are actually reviewed. The remainder are settled outside of court. There are 13 U.S. courts of appeals. The area that the Court of Appeals covers is called a circuit. We in California are in the 9th Circuit. A couple things about Court of Appeals. There are no juries in a Court of Appeals, so cases are heard by the judges alone. Usually a panel of only 3 of a circuit's judges hear any one case, although some important cases may be decided by the entire court. Courts of appeals do not hold another trial of cases they're reviewing. So if you appeal your case and it gets heard, you don't get to have another trial. What the decision is based off of, what the judge makes their decision on, is 2 types of information: the written record from the district court trial and briefs or written legal arguments submitted by both sides of the case. So this is different because basically a appeal is all based on written documents, not on oral presentation. Along with the district courts and the Court of Appeals, we also have special courts. there are 1, 2, 3, 4, 5, 6 special courts. They are the U.S. Court of Claims, the U.S. Court of International Trade, the U.S. Court of Appeals for the Armed Forces, U.S. Territorial Courts, U.S. Tax Courts, and the U.S. Court of Veteran Appeals. Now, each of those only hears specific type of courts, and they're pretty self-explanatory. You know, if you go to the U.S. Court of Veteran Appeals, they only hear lawsuits brought by veterans against the federal government. All right, last but not least, the actual federal judges. Most federal judges, not including those who preside over special courts, serve for life, although Congress can impeach and convict them for serious crimes. The reason our founding fathers gave judges life terms is so that they could remain independent of political pressure, so they wouldn't be pressured by different parties to, make their decision one way or another. Okay, so we get district court appointments. By far the largest number of judicial appointments are those to district courts, because there are so many district court positions. And because there are so many of these positions, the nominations of district court judges are handled mostly by the Department of Justice and White House staffers, not by the president. The traditional principle in making district court nominations has been senatorial courtesy. And what that means is that the executive branch allows senators in the president's party to approve or disapprove each potential nominee for a position in a district court in their state before the official nominations are made. Usually, other senators will follow the lead of those senators and approve the nominee. In return for this courtesy, the Senate confirms almost all the president's nominations for the district courts. So there's a little I scratch your back, you scratch mine going on there. Then we get to Court of Appeal appointments. Individual senators have less influence over the appeals court nominations. Appeals court appointments involve several states, so senatorial courtesy does not play a role here. So senators from California don't get to play a role, really. On the other hand, because of the vital role of the Court of Appeals in interpreting the law and setting precedent, the Senate examines appeal court nominations far more carefully than those for district courts. Another reason for this closer examination is that the appeals court judges are more likely to later end up serving on the Supreme Court. So, the way the ladder works is you start down on a district court, move yourself up to a Court of Appeals judge, and then you're pretty much looking at a straight shot, well, maybe not a straight shot, but a shot at the Supreme Court.